Thank you, Chairman Levin. In February, March, and again in May, this subcommittee held hearings on China. At all of them, I stressed the need to achieve a balance, that we look at our economy as a whole and accommodate the interests of import-sensitive industries as well as those of U.S. industries that need imports to stay competitive. Throughout, my message has been consistent. It won't change today. To me, the issue is basic fairness. Let's treat all U.S. manufacturers equally. I am therefore eager to discuss H.R. 1127, a bipartisan bill that would allow U.S. manufacturers like the auto industry that rely on imports subject to AD or CVD orders to participate meaningfully in trade proceedings before the Department of Commerce and International Trade Commission, instead of being locked out of the process. Much is at stake for these industrial users, particularly when it comes to China. There are 62 existing anti-dumping duty orders on Chinese goods. 62. 50% of the pending anti-dumping and countervailing duty investigations are on Chinese products. Based on these statistics, it appears that our China trade enforcers have been pretty busy, especially when you also consider that USTR has filed 6 different WTO cases against China since 2004, an unprecedented flurry of activity for the United States since the WTO agreements were up and running in 1995. And there are several bills pending in the Congress that seek to ratchet up not only attention toward, but duties on Chinese imports. There's one problem, however. All of these bills would have the United States run afoul of its international legal obligations and potentially face retaliation. Some proposals present unabashed violations, like the bill that would require the United States not to comply with WTO appellate body decisions prohibiting the practice of zeroing in investigations. I just don't see how we can expect China to comply with WTO rulings when we thumb our nose at the adverse decisions we don't like. Other proposals are a bit more subtle, like the bill that would apply the CVD law to non-market economies like China, which I support, but the bill mandates that commerce measures this subsidy benefit irresponsibly and leave it powerless to address instances of double counting. I haven't even mentioned the China currency bills. The USTR, Commerce, and Treasury seem to have removed all doubt there. However, as they recently informed lawmakers that this legislative approach appears to raise serious concerns under international trade remedy rules and could invite WTO-sanctioned retaliation against U.S. goods and services. It would also substantially weaken the position of the United States in our ongoing efforts to achieve essential economic reforms in China and around the world while jeopardizing our rapidly growing exports. Mr. Chairman, I'd like to put this important letter in the record. Retaliation could come through mere legislation that would increase duties on our exports and through withdrawal of trade concessions like intellectual property protection. Either way, it would hit our exporters hard. In the first quarter of 2007, U.S. exports to China were up 15% from the first quarter of 2006. Last year, U.S. exports to China grew at a faster rate than imports from China did. But even before we start talking about retaliation, we ought to recognize that increasing duties on Chinese imports to unfairly and artificially high levels hurts globally integrated companies that rely on imports to stay competitive. Not only does it hurt them, it harms the U.S. economy. Thank you, Mr. Chairman.
And thank you. This will be